One tactic that many lawyers like to use to destabilize the witness that they're questioning at a deposition or a trial is asking inflammatory but hypothetical questions. The good news is that if you know how to deal with those questions, and if you know how to answer that type of questions, then you're not going to have a problem at all, and doing it is very, very easy. So let me give you an example. Let's say you have a business dispute where you have been accused of stealing $1,000. Or let's say that you've been terminated from your workplace. You claim, I don't know, age discrimination or race discrimination, and the employer claims that you stole $1,000 from the company. So the lawyer who represents the employer is asking you the following hypothetical question, and you are Mr. Jones. Mr. Jones, would you agree that stealing $1 million from your employer would be wrong and it would be a crime? The wrong way to answer would be, oh, I've never done this. What are you talking about? This is completely wrong. This is outrageous. Remember, he's not accusing you. He's asking you a hypothetical question. Would you agree that stealing $1 million is wrong? If you become irritated, if you get defensive, it's going to make you look bad. It's going to make you look bad at a deposition. It's going to make you look even worse at trial. Why? Because of your very response, because of your very demeanor. The right and the simple way to answer this type of simple question is to say, yes, of course. Yeah, stealing $1 million is wrong. Would you agree that murdering someone is wrong? Yes, of course. Would you agree that vandalizing a house is wrong? Yeah, sure. That doesn't mean that you agree that you done it. It doesn't mean that you admit to anything. All it means that you agree with a very simple and obvious hypothetical proposition that the lawyer who is asking you questions is making. And that's okay. It doesn't hurt you, and it doesn't hurt your case in any way. So listen to the question. Don't assume that you have to fire back in response to every deposition or every trial question. If it's a hypothetical question, deal with it as such. Don't become angry. Don't become emotional. Don't become defensive when there is no reason to be that way. Remember, when you're in a courtroom, especially if it's not a bench trial, but it's a jury trial, where you have 8 or 12 people sitting and looking at you who have never met you, any type of behavior by you that shows anger, that shows defensiveness, that shows temper, will hurt your credibility. And you don't want to do that. The lawyer who will be asking you those hypothetical questions will likely be counting on you losing it, on you getting angry, and you becoming less believable in the eyes of a jury. If you follow this simple advice and you answer those types of inflammatory questions politely, quietly, and calmly, then it's not going to be a problem for you at all. Keep this simple tip in mind because it comes handy in all types of cases, because hypothetical questions can be asked in any type of civil case and any type of criminal case. And if the lawyer somehow tries to make an outrageous, far-reaching leap between that question and a more direct question about your conduct, then you can look at the next question and you can answer it accordingly. Example. Would you agree that stealing $1 million from an employer would be wrong? Yes, I agree. Isn't it true that you stole $1 million from your employer? No, I didn't. As simple as that. Thank you for watching, and I hope you find this tip useful.